3 months after sentencing, I received a letter from Staff Sergeant Elena Ruiz. One line in it stayed with me. On October 12th, he was there before sunrise, setting out coffee cups with both hands like it mattered how each one landed. That was the moment I understood the sentence had begun to do exactly what I built it to do. I want to tell you how we got there. I want you to subscribe before I keep going. Not because what I am about to tell you is dramatic, because it is the opposite of dramatic. And those are the stories that need the most people to hear them. Subscribe and turn on notifications. Then let me continue. The first thing I saw was the file: battery, disorderly conduct, public intoxication. A hotel entrance on East Bay Street in Charleston on June 14, 2025 at 9:18 p.m. A man from one of the city's old money families had spat on a soldier in uniform. On paper it looked simple. The law often arrives in simple words. Human beings do not. The papers grew thicker over the next 10 days. Body camera footage, a hotel incident report, cleaning invoices, a victim statement, a pre-trial memo from the defense that did not deny a thing. That last part mattered. When the truth is already settled, the work of a court changes. I am no longer deciding what happened. I am deciding what should now be built around it. There is a tool in the process most people never hear about. It is called a presentence investigation. A probation officer interviews the defendant, checks records, verifies treatment, work history, family ties, prior conduct, and puts together a fuller picture than a police report can hold. If someone asked me at a kitchen table, I would say it this way: it is how a court avoids mistaking a person's worst hour for their whole life. That is also where discretion begins to matter. Discretion does not mean I get to ignore the law. It means the law allows me to look at more than the label on the charge. I can consider what happened after arrest. I can consider treatment, employment, truthfulness, the victim's actual request, and whether accountability can be shaped into something useful instead of merely blunt. That is not softness, it is part of the job. The defendant was Adrian Vale, 34 years old, well known in Charleston for showing up in local society pages beside donation checks and gala backdrops. When he walked into my courtroom, I noticed one simple thing first. His tie was straight, but his collar button was off by one. Someone who lived in polished rooms had come into mine looking as if he had dressed in a hurry and then stood in the parking lot too long before entering. Then I noticed something else. Before he sat down, he turned off his phone and handed it to his lawyer without being asked. People do not understand how much I see from the bench before anyone says a word. Small acts matter. They do not prove character, but they can tell me whether a person has come to perform or whether they know enough to stop reaching for escape every time discomfort appears. Staff Sergeant Elena Ruiz was 28, Army medic, South Carolina National Guard. She entered with her mother and carried her service cap in both hands. She did not look toward the defense table. She did not need to. What I saw in her, almost immediately, was control. Not coldness, control, the kind that costs something. When she later addressed the court, she did not ask me to crush him. She said, "I do not need him broken. I need him to understand that there was a person inside that uniform." That was one of the clearest victim statements I have heard in years. She was not asking for theater. She was asking for recognition, structure, and truth. The incident itself had been witnessed by enough people that the outline was not in dispute. 2 events were ending at the Marston House Hotel that night. In the South Ballroom, there had been a museum fundraiser. Upstairs, there had been a military scholarship dinner. Adrian Vale came out of the fundraiser after hours of drinking. Staff Sergeant Ruiz was standing near the valet lane, waiting for her mother to bring the car around after the scholarship event. The lane was backed up. A rideshare had stopped too long. A delivery van had clipped the flow of traffic. Adrian wanted his car brought forward at once. A valet told him to wait. He looked toward Sergeant Ruiz, saw the uniform, and said, "I am tired. I have had enough, and I want this line moving." She told him everyone was waiting, and he needed to step back from the curb. He stepped closer instead. Witnesses agreed on the next part. He said something about special treatment, leaned forward, and spat. It hit her across the cheek and collar of her dress blue coat. On the body camera video, there is a 1 second stillness from her before anything else happens. I know that stillness. It is the body catching up to humiliation. The hotel manager gave her napkins. Someone called the police. Adrian was detained at the scene. In the body camera audio, after officers separated them, he said, "I did that. Don't say I didn't." That sentence did not erase the act. It did matter. I had one early sign that I would not be dealing with a defendant determined to lie all the way through the room. Subscribe before I keep going. I am still thinking about what this case taught me. Subscribe, because before this video ends, I am going to try to say it out loud, and I want you to be here when I do. Subscribe now. From the bench, I watched everyone enter with the kind of attention this work teaches you if you stay in it long enough. Adrian came in behind his lawyer, but he did not sit right away. He turned once toward the gallery, found his mother, and gave a small shake of his head. "Stay still. Not now." It lasted less than a second. I saw it. Sergeant Ruiz entered a minute later. Her pace was measured. What I remember most is that before she sat, she reached back and centered her mother's chair with one hand without looking. A person can tell you a lot with a movement that small. She had not come to court to be made larger by someone else's fall. She had come to get through it with the people she loved still steady behind her. The first turn in the case came from the probation officer who prepared the presentence report. She testified about her interview with Adrian 2 weeks after the arrest. She said, "When I asked him what he could not stop thinking about, he said the sound of the napkin packet opening while she stood there. That sentence changed the way I read the rest of the file. It was not legally significant by itself. Humanly, it was. He was not talking about the newspapers, his family, his business, or his own booking photo. He was talking about the exact moment another person had to clean his contempt off her face in public. Shame is often selfish, but when it lands on the precise harm and stays there, I pay attention. I did not suddenly trust him. Trust is not my task. Testing is. So I went back through the materials asking a different question, not whether he sounded sorry. Many people can do that. I asked whether he had begun to describe the harm without dragging himself back to the center of it. That is a narrower road. Fewer people can walk it. The state's evidence filled in the damage with detail. The replacement cost of the coat was $1,126. Alterations and insignia transfer added $286. Cleaning and evidence handling added another $130. Sergeant Ruiz lost 1 day of civilian hospital wages, $300 before tax, to attend an early hearing. Her mother drove 108 miles round trip for 2 court dates. Those numbers matter. Courts should name actual cost in actual figures. Then came the part of the process most people never see. The rules allowed me to consider a suspended sentence tied to strict conditions if the record supported it. In plain language, that meant I could impose the full jail term allowed on the count and then hold part of it over him while requiring work, treatment, and supervision. It is one of the few tools the law gives me to turn a sentence into something shaped rather than merely dropped. At that point, I knew the harm plainly. What I did not yet know was whether the record gave me any lawful reason to build toward repair instead of only confinement. Outside the courtroom, people hear a summary and think they know the whole shape of a case. I was not outside the courtroom. I was in it. That changes what I am responsible for. Subscribe before I continue. I have been building to something in this story, and it is not where you might think it is going. Subscribe and let me get there. The second turn came from a stack of attendance sheets and a man named Daniel Mercer, who ran the Harbor House Recovery Kitchen. Adrian had entered outpatient alcohol treatment 48 hours after release. That alone would not have moved me much. Many defendants do something quick after arrest. What mattered was what followed. Mr. Mercer brought work logs covering 76 straight days. Adrian had been reporting at 5:30 a.m. 3 mornings a week to unload food deliveries, scrub prep tables, and wash stock pots in the back kitchen. No foundation logo, no press release, no photographs, just initials on a clipboard verified by staff, next to jobs most people only notice when they are left undone. Mr. Mercer did not oversell him. That helped. He said, "He does not choose the visible work." Then he stopped speaking until the next question. From the bench, restraint matters. I trust people more when they are careful. The room shifted after that testimony. Adrian's mother pressed two fingers to her throat. Sergeant Ruiz looked at him directly for the first time all day. That evidence required something from me. It opened a decision that had not been truly available before. I could now shape a sentence around supervised usefulness because I had facts showing he could show up for hard, quiet work and continue showing up when no one praised him for it. That is not everything, but it is not nothing. The defense then made an argument I was already inclined to hear. Adrian's lawyer said, "If you send him home with only money, he learns that wealth can absorb shame. If you send him to jail and release him without structure, you may teach him less than you think." That was more honest than most sentencing arguments. She was asking for labor, treatment, and time hanging over his head. She also got one part wrong. She leaned too hard on alcohol, as if drinking had appeared from nowhere and committed the act by itself. I do not sentence bottles. I sentence people. Alcohol lowered his restraint. It did not invent the contempt. If I had built a sentence on that excuse, the whole thing would have rested on a false foundation. Then Adrian testified. His first useful sentence came early. He said, "I had been drinking since lunch because I did not want to be at that fundraiser and I did not want anyone to notice that." That told me something true about his circumstances, not an excuse, a fact. He was living inside a life he knew how to perform and did not know how to inhabit. Later, when asked whether anyone pushed him into the act, he said, "Nobody made my mouth do that." I listened closely when he said it. Short sentences matter in court. Long ones often hide. Short ones stand there and take the weight. The sentence that decided the case for me came near the end. His lawyer asked why he kept returning to the kitchen after local interest in the case had faded. He said, "I needed to learn whether I could finish a hard day without applause." That was the moment I knew what I was going to do. I wrote it down, not because I needed to remember it, because I wanted to. Subscribe. I am not going to make a speech about it. You are already in this story. Subscribe and let me finish. Around then, a memory came back to me from my own life. I was 13, standing in the basement of my grandmother's church on a hot July afternoon, watching my cousin Leon sand the rough edges of folding tables after he had broken windows behind a grocery store. An old Marine named Mr. Haskins stood beside him, saying very little. He would run his thumb along the wood, hand the table back, and say, "Do it smooth enough for the next person." The room smelled like dust and lemon oil. Leon's forearms were red from the work. Mr. Haskins did not give him a speech. He gave him a standard. I had not thought about that in years. I did not explain it in court. I did not need to. It sat beside this case while I listened. By the time both sides rested, I trusted three things. I trusted the proof of harm. I trusted the victim's clarity about what she actually needed. And I trusted enough of Adrian's conduct after arrest to believe that a tightly built sentence could do more than a blunt one. Not because he deserved ease, because the evidence supported structure. Before I spoke, I looked out at the room. Adrian had both hands flat on the table. Sergeant Ruiz had her cap in her lap and was rubbing the edge of the brim once with her thumb and then stopping. The gallery was still in the way people get still when they are waiting to learn whether the law is about to close a door or mark one. I had made the decision carefully. I had made it knowing that mercy, to mean anything, has to be precise. Vague mercy is only hope. Precise mercy is a plan. I had a plan. I have not told you the full sentence yet. I am about to. Subscribe before I do, because I want to explain every part of it, and the explanation is as important as the ruling itself. Subscribe now. On the battery count, the law allowed up to 12 months in county jail. I imposed the full 12 months. That part mattered. The act was public, degrading, and driven by entitlement. The sentence had to say so clearly. Then I suspended 10 months on strict conditions because the same law that let me mark the harm also let me shape the path forward. I said, "Mr. Vale, I am ordering you to pay $1,842 in restitution to Staff Sergeant Elena Ruiz for the replacement of her dress coat, related tailoring, cleaning, lost wages, and travel connected to this case. I am also imposing a fine of $2,500 to the Low Country Veterans Mobility Fund. I chose that because money cannot repair humiliation, but a court still has to name loss plainly and make the person who caused it pay actual cost. I said, I am also ordering 320 hours of restorative service at the Low Country Veterans Resource Center to be completed within 12 months in duties assigned by the director. Those duties will include setup, cleanup, kitchen support, loading supplies, and intake work. They will not include public relations, donor events, or any role that turns service into display. I designed that because the harm was public. The answer, as I saw it, was not public shame in return. It was supervised usefulness. I said, you will serve 18 months of supervised probation. During the first 6 months, you will attend weekly alcohol counseling and submit to random testing. During that same period, you will maintain at least 30 hours a week of lawful employment or approved education outside any business owned or controlled by your family. I required that because the record showed me a man who had been carried too long by money and routine. He needed structure that asked something of him. Then I added one more requirement. I said, beginning in month 3 and continuing once each month for 1 year, you will work family support nights for households with deployed service members at that same center. You will set tables, serve meals, clean the room, and stay until the work is done. If Staff Sergeant Ruiz ever chooses to participate, the probation office may arrange one restorative conference. If she does not choose it, it will not happen. That choice is hers. Then I gave him the benchmark for early reduction. I said, if by July 1st, 2026, you complete all 320 service hours, maintain 12 continuous months of verified sobriety, and record 9 straight months of full compliance with work or school and no probation violations, I will entertain a motion to reduce the remaining suspended portion to unsupervised probation. That was my way of placing a handle on the door without pretending he had already turned it. I believed Adrian Vale could do it. Then I spoke to him directly. I said, what you did was degrading. You took your frustration, your drink, your status, and your contempt, and you put all of that onto another human being's face in public. Staff Sergeant Ruiz carried the cost of that in her body, in her uniform, in her work schedule, and in the burden of coming through this courtroom. Then I said, but the charges before me do not contain all of you. They contain the worst act in this file. They do not contain whether you will become disciplined, useful, and honest in the years after today. That part is not written yet. I ended with one sentence addressed to him, not to the case. I said, Adrian, do not ask the world to think better of you than your work allows. The first reaction I noticed was not his. It was his mother's. She let out one breath, set both palms on the rail in front of her, and lowered her head for a second before looking up again. I did not interpret it in that moment. I just saw it. Subscribe. I am about to tell you what happened after the sentence. Whether this person did what I believed they would do. Subscribe so you are here for that part. It is the part I care about most. As the courtroom began to empty, something happened that I still remember with unusual clarity. Staff Sergeant Ruiz walked back toward the defense table, took a card from her pocket, set it beside Adrian's folded hands, and said, if you show up early. Then she left with her mother. That was all. Before I stood, I squared the file with the edge of the bench and capped my pen. I have done that thousands of times. On that day, it felt different. The specific thing I later learned came through that October 14, 2025 letter from Sergeant Ruiz. She reported through proper channels that she had attended a family support breakfast at the Veterans Center on October 12th. She wrote, he was there before sunrise, setting out coffee cups with both hands like it mattered how each one landed. Later in the letter she said, he does the jobs nobody claps for. I have kept both sentences. No appeal was filed. I noted that honestly. Sometimes that means very little. In this case, with experienced lawyers on both sides, I took it as a sign that the sentence had been received as lawful, clear, and worth carrying forward. I have come to believe that mercy without structure is only a mood, and punishment without purpose wastes chances the law is sometimes still able to reach. Acting on that belief costs something. It takes time. It takes a closer reading of people than many think judges owe. It would have been easier to give straight time, close the file, and move on. What this case gave back to me, not as a judge but as a person, was a small piece of trust in steady work. If you have been where Adrian was, and you have caused real harm, I am not going to offer you comfort. I will tell you what I look for from the bench when deciding whether someone is ready for something other than the maximum weight available. I look for clean ownership. I look for the person who can say what they did in plain words and name who paid for it. Then I look for boring effort. Early mornings, kept appointments, finished tasks, no audience. If that is useful to you, then use it. Stop trying to look changed and start doing work that would still be worth doing if nobody ever praised it. If you have been where Sergeant Ruiz was, I would never tell you what kind of mercy to want. That choice belongs to you. I can only tell you what I have seen. When victims choose a measured form of mercy on their own terms, it sometimes returns a sense of authorship to them, not because the harm gets smaller, because their voice is no longer limited to pain alone. That is an observation, not a rule. Some harms need distance, some need a wall, some need nothing except survival and peace. Courts should know the difference. Victims often know it first. Now I want to return to the image I gave you at the start. October 12th, before sunrise. Coffee cups in both hands, placed carefully on folding tables for families connected to service members. That is why I told you this story. If you want to hear the others, and there are others, subscribe. That is all I am asking. Subscribe and stay. In the comments, speak to each other the way people speak in a courthouse hallway after a hard hearing when they still believe justice and humanity can stand in the same room.